I think the main legal challenge is um, not taking enough time to prepare. The market, it typically suggest you prepare 5 years in advance, even 7 years in advance, rather than I'm thinking about selling and then you're going to pivot to sell. I think that's probably one of the biggest challenges I face with clients. And if you go to any seminar on practice transitions, you're going to hear that prepare, 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 because then your practice is going to be in a position um, to transition probably the most successfully if you've prepared several years in advance because you're able to tweak financial, regulatory, operational issues in order to get the most value for your practice. That's a great question. The first document is a non-disclosure agreement. That's going to enable the parties to discuss the transaction and share information. Once the information is shared, typically the buyer will offer um, a letter of intent to the seller with the terms that they want to buy the practice for. That letter of intent is non-binding, except there is a provision in the letter of intent that is binding. It's called exclusivity. Whenever you're a seller, whenever you're a buyer and you enter into a letter of intent with a seller, you want that seller to be focusing on you. You, as the buyer, are going to spend some time and money on preparing or looking at the practice. So you want to make sure that seller is not continuing to shop it around. That's typically the one important provision that's binding, that in confidentiality. But that letter of intent doesn't require the seller to sell or the buyer to buy. It is just it lays out the terms of the deal. And then once the letter of intent is signed, the attorneys will take that letter of intent and they'll incorporate that agreement into what they call an asset purchase agreement, which is a typical document that enables the seller to sell and the buyer to buy the practice. In addition to that, depending on how the real estate is held, if the seller is going to sell the real estate along with the practice, there'll be a contract for the sale of real estate. If the seller is a tenant or is not going to sell the real estate, there'll either be a new lease that's entered into between the landlord and the buyer as the tenant, or there'll be a lease assignment that's entered into between the landlord and the buyer as the tenant. And then sometimes they'll also consider a key document will be an employment agreement of either the seller or their key associates that they have in a practice. And in a corporate sale, there'll be also most likely if there's going to be a sale of a percentage of the practice, 70% of the practice, there'll be other documents that the seller will enter into in order for the seller and the buyer to be partners after the closing. Most sales are structured as asset sales. So and it's done that way because the buyer in an asset sale only assumes those liabilities that are specifically set forth in the agreement. Um, it's very rare that you'll see in this industry that a sale would be what you'd hear a stock purchase or a membership purchase. It's typically an asset sale. And I always tell a client, think about a wall going up. And if you're buying a practice, you're only going to assume those liabilities and that'll come through that wall that are specifically set forth in that agreement. That's number one. And then number two, um, within that agreement, how is the purchase price going to be allocated? Because that's going to have tax implications. Typically, in an asset sale, 80-90% of that purchase price is allocated towards goodwill, which is good for the seller because then it's going to be taxed as a capital gain, which you're looking at anywhere from 15 to 20%. The other percent is going to be that's taxed. The other part of the purchase price is going to be taxed on furniture, fixtures, and equipment, and that's taxed at ordinary income. So, typically we're working with our client's accountant on the allocation. It's got to be fair. Usually in a corporate sale, most corporate buyers, as allocate 90% of the purchase price towards goodwill, which is great for the buyer, great for the seller because it's much more tax advantageous. Other key provisions in the agreement, representations and warranties. We spend a lot of time with our client, whether you're representing a buyer or a seller, on the representations and the warranties. I look at the reps and warranties as doors. And I always tell the client, those are doors that a buyer can get out after the seller in the event that the seller is not truthful and honest about the reps and warranties. There's no litigation. You have clear title to the assets. You've paid your taxes, things of that nature. Those reps and warranties typically have a survival life, a period after the closing, anywhere from 1 to 2 years, which is negotiated by the attorneys. And I think two other key provisions in the agreement are indemnification and restricted covenants. So indemnification, I really try to simplify for clients. If we close today and I'm representing the seller, I always tell the client, the seller, we close today, and 6 months from now, the buyer gets sued for something that you did while you're the practice owner. You're going to stand in front of that buyer and say, no, it's not the buyer's fault, it's my fault. You're indemnifying them. And I use the same analogy with the buyer and the seller. And that's important. Fortunately, knock on wood, I think I had one post-closing issue in the 15 years I've been representing veterinarians in this industry, dealing with indemnification. And then lastly is restricted covenants. Everybody's familiar with the term non-competition, non-solicitation, and people kind of get hung up and say, oh, they're not enforceable. The restricted covenants are different in an employment situation as opposed to a business transaction. When a buyer is buying the practice, part of what they're buying is the buy you seller out of the market for a period of time. So they are enforceable because there's consideration being paid for that covenant. Typically, the term we see anywhere from 3 to 5 years post closing. And then from a radius, depends where the practice is located. If you're in New York City, there's going to be a radius, maybe several blocks to the east, several blocks to the west. If you're out in rural Wyoming, it could be 25 or 30 miles, depending. I always say where you're drawing your clients from. That's typically a fair radius for the non-compete. Then you have non-solicitation, where you're not going to solicit the practice's clients, employees, or referral sources. Term is typically the same as what you have in the non-compete portion of the asset purchase agreement. They go kind of timing and rushing through the process. You got to be prepared. If you're going to sell your practice, mentally you got to be prepared, because once you bring it to market and you have a ready and willing, able buyer, you want to be able to move on that buyer. What does that mean? Be prepared. Be ready to go. Have all your documents, from your practice, and all any associates that are under contract. Your financials are in good order. Yeah, there's no litigation. If you have an outstanding loan, you have those loan documents ready and available. Because once you get into the transaction, you're going to start spending time and money, and the attorneys and the accountants are going to get involved. You kind of use the analogy: you go to the doctor, due diligence. It's almost like going to a doctor, and it's a chance for the buyer to see the seller with his pants down. It's kind of a crude analogy, but it really is, because the buyer wants to see the good, bad, and the ugly with that practice. And the more good there is with that practice, the more you can support the purchase price that you have. So being prepared and ready to sell, and having your team in place. If you're a seller, having the team in place, starting with the practice broker, engaging a practice broker early who can kind of hold your hand through the transaction from the very start with a non-disclosure agreement, gathering the information and bringing your practice to market, looking at all the letters of intent, figuring out what one from a price and culture makes sense for you. an accountant, having a good accountant who understands the veterinary industry, um, having an attorney who understands the veterinary industry. I can't tell you how many times I've worked on transactions that are pretty, black and white, and maybe the seller went ahead and hired a friend's who was at a golf club. That attorney there, and you're putting like a square peg in a round hole. They're creating issues that are really unnecessary. I think having your advisory team is something that we preach to our clients all the time. Legal considerations. Yep. If you're no one, if your associates possibly aren't under contract, and you have key associates there that are you need to have go along as part of the deal. I think that could be a real problematic because there's been numerous occasions where we go ahead, get the deal all teed up, and then we have to deal with the two or three associates at the practice, and maybe they don't have contracts in place. And then there's a whole nother negotiation that has to go on with those associates. The real estate. How is the real estate held? Are there any issues with the real estate? If you're leasing your space, I always ask the client, how's your relationship with your landlord? Is it a good relationship? I have one right now where my client's looking to sell. We were supposed to close over 2 weeks ago. My client leases a space, and the landlord's being very, very difficult. One, about releasing my client from the guarantee that my client entered into years ago. And then two, accepting the assignment language that the buyer wants to have the landlord enter into. And the buyer is a pretty large corporate buyer. So that landlord is going to be in a much better position with the buyer. And I said, no offense to my client, and my client understands that, than they are with my client who's a single member owner. Any outstanding liabilities that the practice may have, a debt, any pending litigation, you want to make sure that all of that's under control, especially with pending litigation. It's that's all released, satisfied. Any judgments, anything like that, are taken care of ahead of time, and then making sure that there's no licensing or compliance issues, which we typically don't come across. Most of the time, the clients, the seller has his or her license in place, or their associates. I had one recently where one or two of the doctors had let their license lapse, and it was just another hurdle we had to come in a transaction. And you're just trying to reduce or minimize those hurdles so that the transaction can be take place as smooth as possible. Any liabilities that seller can retain after an asset sale? Well, as I mentioned earlier, with regard to indemnification, um, there's certainly going to be several that you're going to stand in front of the buyer for on an asset sale. Things that happened while you were the seller. And it's negotiable in terms of one, what those items are, and two, how long you're responsible for. So let's take it one at a time. So how long you're responsible for. A lot of times in those agreements, we try to you try to minimize, if you're representing a seller, a period of time, 1 year, 2 years, that you're going to be responsible for, standing in front of your indemnification obligations or the representations that you're making. Depending on the buyer, there may be certain fundamental representations you have as a seller that can even last longer than whatever's negotiated. It could be there should be statutory limitations on there. So it just really depends on who the buyer is and what the parties negotiate. But yes, there definitely are obligations as a seller that are going to carry forward after the sale, which is why you need to understand as a seller what those are and what risks may or may not be exposed you may be exposed to. It's a really interesting question, and it's depending on what state you're in. The answer can differ. It really depends. I think you got to be prepared as a seller that you're not going to work for a period of time after you close or sell your practice, except for working for the buyer. And if I'm representing a buyer and buyer comes to me with practice they want to buy. First thing I'm asking them, one of the first things is, what does the seller want to do after we close? And oh, they're going to retire. I'm like, oh, great. In the back of my mind, I'm thinking that's one less thing issue we're going to really have to deal with. The seller's not going to care how long the non-compete term is or how long the radius is. And it always raises the question in my mind when you get into the transaction, all of a sudden the seller starts pushing back on that. I'm saying to my client, well, wait a minute. I thought you said he or she is going to retire, so why do they care? But it's just got to be reasonable. And typically in the industry, you close today, it should be expected that you're not going to compete against the buyer for at least 3, not 5 years. And depending on where you are in the country and where you're drawing your clients from, and also what type of practice that you are, large animal, companion animal, or specialty practice, all have different radiuses where you're going to be drawing your clients from. One is staying on the restricted covenant. You want to have language in there that they're not going to compete against you. Obviously, you want to set forth the term of their employment, how long that's going to be, their compensation, what benefits they're going to have, what their role is going to be. I look at the employment agreement almost as it's a roadmap, and it's a great communication device between the employee and the employer to set the expectations. Because any business is only as good as the employees who are working for them. And you also want to have no conversation. What's that employee's goals? What do they want to do? With some transactions we've worked on, some buyers, especially on the corporate side, will say, listen, if that an associate, if he or she wants to get equity, we're willing to have that conversation. And some want it, some don't. It just depends on the associate. But it's important. It's to your point earlier, to your question that you asked, it's definitely one of the critical documents that needs to get discussed, negotiated, and executed on or before the closing. I'm going to go back and like I'm beating a dead horse. Is prepare, prepare, prepare. Think of from a financial standpoint. Um, you know, the more you're prepared and the more your house is in order, the better the smoother the transaction is going to be, and the less opportunities the buyer is going to have to try to renegotiate the purchase price. I maybe I try to simplify things, um, but I like to kind of draw on basic analogies. You're going to sell your home. You don't want to have your home outdated and stuffed with a bunch of stuff when a buyer is going to come in there and they're going to be discouraged by it. You're going to want to make sure you have your house in order. Why you want to start in advance. Why in the industry they say at least 5 years in advance to sell. I've even heard some those consultants say you should operate your practice like it's going to be sold in 6 months. I know it's easier said than done, but if you, from day one, if you're operating your practice like that, and you have your financial house in order, you have your operational house in order, you have your legal house in order, you should be ready to pivot. And if an offer comes around that you want to entertain, you should be able to entertain that offer, have the requisite documents ready and available to that buyer for the buyer to take a good look at your practice to say, wow, this practice is something I'm really excited about and I want to make an offer on it. The seller financing, actually, I've had a couple of those come up recently um, over the last, I'd say, 6 months, where you representing, and I'm on both sides, you're either representing a buyer who maybe can't get financing. Maybe their student loan debt is too great. Maybe they miss several payments with their student loans, which really ding their credit. So they can't go to a conventional lender or an SBA lender to get financing. So what do? Maybe the seller is willing to finance that transaction for them. So perhaps the buyer is going to go to that closing, pay a percentage of the purchase price, maybe 10% in cash or some other dollar amount at closing. And then the remaining balance is going to be financed over a period of time. And there's so many variables that, you can work with on that. So the buyers come into the closing with cash and a promissory note, which is like a legal IOU to the closing. And then the seller is serving as the lender in that situation to the buyer. And you see that I've seen it in the last 6 months where sellers are entertaining that when they have a key associate or somebody they're really interested in selling to, and they really want to try to help them out. I've also seen a combination of maybe conventional financing with seller financing on top of it. So maybe my client will go and get a loan from a conventional lender, and then in order to bridge that gap, because they didn't get complete financing that they needed, the seller is going to lend them some money too. So you're going against a combination of cash and um, uh, a note at closing. I do have one situation where actually the seller is just, they're really not interested. My client can get conventional financing, but the seller doesn't want the seller wants to loan the money to my client who's the buyer as a transaction, which is interesting. But she's like, I don't need the money right now. I'd rather loan it. And that's how I just want to structure it. So if my client wants to buy that practice, she's going to have to, accept the seller financing um, from the seller. On the earnouts, you see that it's a little more riskier involved because you're kind of betting on yourself that the practice is going to continue um, to produce. The better the practice does, the more money that you can make in an earnout. And it's kind of like the buyer and the seller sharing in that risk, with an earnout. So maybe the buyer is willing to pay X amount of dollars at the closing and willing to pay, Y amount of dollars after the closing, provided that the practice reaches a certain level of performance. Whereas, you as it's really an incentive to keep the seller, vested. Back during the COVID boom, and I think we all of us saw so many of the corporate buyers in the market doing all cash deals all the time. And I think some of them maybe have gotten caught with sellers just kind of checking out on them. And maybe they didn't do good enough due diligence on that practice. And then the seller's not there anymore to transition to goodwill. They've taken their money and they left. Well, here, where, in an earnout, you kind of you're keeping a carrot in front of that seller in order, hey, it's a win-win. The practice performs at how we both want it to perform. You're going to get paid, and so are we. When you say in payment terms, you're talking about in the event that it's not a sale of like 100% of the practice, something
Yeah.
along those lines. Some of the pitfalls. So you want to make sure whatever benchmarks are set in the agreement, that you as a seller can meet them. If the practice hasn't performed at that level previously, and then you're not going to be able to reach those benchmarks, you're going to have a problem, capturing that additional purchase price money in the future. One, and then two, a lot of times we talk about put and call rights. Understanding, you as a seller when you sell your practice, if it's going to be, if you're going to get some type of equity in the parent company, or there's going to be some type of joint venture with you and the buyer, how do you effectively exit out of that? Do you have the ability at some point in time after you close to what we call put it to the buyer if you want to and cash out, or you just got to wait for the buyer to call at some point in time in the future, your equity interest? You need to understand that. So sometimes, if you're going to work with um, the buyer after the closing for a period of time as an employee, let's just say 3 years or 5 years, and after you're done working there, you still have equity with that buyer. How do you get it out of there? Um, I think the biggest issue is just not understanding what your rights and responsibilities are as a seller post closing. I think anybody who's been involved in these transactions understands the volume of documents that you got. You're negotiating. We talked about the asset purchase agreement. We talked about the employment agreement. You talked about how you're going to handle the real estate All are documented with complicated transaction documents. And then if you're going to get equity in the parent company, or there's going to be some form of joint venture with the buyer. There's a whole another set of documents that you need to understand. I had a client come to me recently. Um, he was an associate at a practice that sold to a corporate buyer, and he was able to get 20% at the sale in the joint venture entity that the buyer and his practice owner boss created at the closing. And he also got equity in the parent company. So it was a really nice deal for him. He's a young associate. He didn't have an attorney represent him, and he signed the documents. What happened? So now you fast forward, a year later, and he's looking to maybe do some type of other business ventures, maybe with some other people. And then when he had us review the documents, unbeknownst to him, he was really precluded from doing anything on a going forward basis because of the equity that he had taken from the buyer. It wasn't a bad deal for him financially; it really worked out well, but it just goes to show had he known the restrictions that he was going to be binding himself to when he took the equity, maybe he would have thought differently. Probably not because of um, the financial rewards that came along with it. But to not know, I think, is a big mistake. I think you need to understand what the restrictions are that you're going to be entering into after the closing, so you can make a well-informed decision. I think it's very similar to what we talked about. Depending on the agreement, what it says, there are going to be certain responsibilities and obligations for the seller that are going to carry forward after the sale. And depending on the agreement and negotiations that take place, those obligations and responsibilities are going to vary. Whenever, depending on what hat we're wearing, if we're representing a seller, we're trying to minimize those obligations and responsibilities as much as possible. And we're also trying to minimize the amount of time that our client as a seller has to be responsible for those issues. If you switch on the other side as the buyer, I want to make sure that the seller is responsible for the representations or any post-closing obligations as long as possible. Like I said earlier, doors. If I'm representing the buyer, I want to be able to go through as many doors as possible after the closing to get after the seller in the event that the seller made a representation that wasn't true and accurate and caused the buyer harm. If the seller didn't do something that they were supposed to do prior to the closing. So it depends on what side you're on, and it depends on what's negotiated. But it's why, again, I'll end at this: why it's critical to have the right team of advisors around you. When you're entering into these transactions. We don't take it for granted that this is probably the biggest deal that you're going to be making in your life. So you want to make sure who you're hiring as your practice broker, as your accountant, as your lawyer, understands the industry, understands the market, so they can focus on issues that matter and not focus on issues that really don't matter and get in the way of doing the deal. At the end of the day, you're hiring the people to get the deal done for you. Yes, you want to be well represented, but you want to be a deal maker, not a deal breaker. You don't want to get in the way of getting that deal done for either the buyer or the seller. It's critical you have the right team of advisors in place.